Okay, well, good afternoon and welcome everyone. Let me wait for a couple of people are connecting. Let me just give it a couple of seconds. There we go. I think everybody's connected. Just a very quick welcome to all of you. Welcome to our latest lecture at the Center for the Study of the Middle East. I'm Faisal Starabadi, the founding director of the center. First of all, just some ground rules. We will have a sort of a mediated question and answer period when Professor Hanley finishes his lecture. You can either text, chat rather, use the chat to either chat with everybody and send your question, or send it to Dr. Carl Pearson, the Associate Director of the Center for the Study of the Middle East. Or if you prefer to ask your question yourself, we can do that. Just raise your hand, and Dr. Pearson, who will mediate the question and answer session, will call on you. I think those are the only announcements I was asked to make. With that, by way of background, let me just very quickly introduce our guest speaker today. Professor Will Hanley is a legal and social historian of the Middle East. He's associate professor of history at Florida State University in Tallahassee. He studied at the universities of Saskatchewan, Toronto, and Oxford. And I'm pleased to say that there is an Oxford comma in that sentence. Before taking his DPhil in history, I beg your pardon, his PhD in history at Princeton. His first book, Identifying with Nationality, Europeans, Ottomans, and Egyptians in Alexandria, was published by the Columbia University Press in 2017. He is currently working on a Cairo-centered history of international law between 1870 and 1930, and is engaged in a variety of digital and digitization projects. His research has been supported by the National Endowment for the Humanities, among others, and include the Institute for Advanced Study. It is my particular pleasure, and I say that as a lawyer by training myself, to welcome Professor Will Hanley and look forward to his lecture, International Law's Middle East Supply Route. Welcome, Professor Hanley.
Thanks very much for the invitation, Ambassador Strabadi, and thank you to Carl for helping me make the arrangements and coming to speak to you today. I am going to present on research that I've been working on for a couple of years, and I'm going to offer a fairly sort of broad and impressionistic view of some of the main questions that I'm trying to raise in this study. And my hope is that I will be able to say some things which will trigger your curiosity, perhaps make you unhappy with things that I'm trying to say in a way that will provoke a conversation that I think can lead us somewhere productive. This project is meant to look at the general field of international law from an unusual angle, and to generate some insights through some efforts to have an unconventional perspective. So I'll try to spell out some aspects of this perspective, for the most part using broad brush strokes, and we'll be happy to get into some of the details, especially in the question and answer. Okay, what is international law? This question is a close cousin to the infernal, unanswerable question, where is the Middle East? We can and must use these very general questions. What is international law? Where is the Middle East? We use these all the time in the classroom, when we're speaking to the public. But in the privacy of our own minds, we don't really believe the answers that we give. An important part of our work as scholars is to probe these provisional answers. And that's what I'm aiming to do in the paper that I'll offer to you today. The short version of my argument about what is international law is that it is a place with Cairo as its capital. Of course, I don't really think that Cairo is the capital of the of international law any more than I believe that The Hague or Geneva or Brussels or London or Paris or New York is the capital of international law. But looking down at international law from the heights of Cairo permits us to re-examine the structures that international law created and the ideas that created it. It's a way of improving our answers to the question, what is international law? There are many reasons that we might want better answers to that question. Those reasons are clearest when we look at the present day, not from Paris or Geneva, but from Egypt or from, any of its neighbors, Syria, from Turkey, from Libya, from Palestine, from Yemen, from Saudi Arabia. All of these places are badly served by international law's promise to gently to civilize nations. And at the same time, we see that these states are makers of a lot of business for international law. They produce enough business for international law to make us wonder who really does control international law, what its nature is. Is it controlled by its lords, or is it controlled by its subjects, the subjects who have to deal with the consequences of international law in the Middle East? Now, I'm a historian, so I'm not going to say much more about the present day, but I do want to point out that just as international law is present, it is a bit hard to pin down, and it's hard to come up with a convincing answer to what is international law. It's hard to pin down the answer to that question in the past as well. For the purposes of this investigation, I'm defining international law as the academic and professional field to which international lawyers say they belong. Thus, when I ask what is international law, I'm not seeking a metaphysical answer to the question. I'm instead trying to learn what the field is made of, to discover the ingredients used to constitute it. I'm not myself an international lawyer, and my approach is the approach of an outsider who must learn the bounds of the domain in which he or she wishes to operate in order to avoid looking like a fool. But this question, what is international law, is not naive ingenuity. I'm a skeptic of many of international law's claims because I understand it as a system of domination. I know that international lawyers depend on their expertise for their authority. And when we ask what is international law, we're meant to rely on experts to tell us what it is. In other words, international law accrues power through mystification. This project is an effort to demystify the field through careful empirical description. I want to look behind the curtain and attempt to understand the mechanisms that established the monolith. I will try to tell this story from the oblique angle of Cairo to avoid reproducing the dominant discourse. To that end, I'm going to ask four basic questions about the makeup of international law: when, where, who, and what. I've arranged these questions in order of increasing difficulty, and through them, I'll set out my view of international law's Middle East supply route. Okay, question one, when? When, as I said, is the easiest to answer. I focus on international law, on the period of international law's establishment as an academic and bureaucratic field during the second half of the 19th century and the first half of the 20th century. Before this time, international law was largely the domain of philosophical thinking and of power politics. And what we see in this picture is a painting of the 1878 Treaty of Berlin, which decided the fate of the Ottomans in many ways. And we can see the Ottomans excluded over to the right of this picture. An article published this year by Mustafa Menawi of Cornell University engages in a close reading of this painting and its meaning for the Ottomans in international law. But I'm not as interested in this power politics domain of international law. Instead, the when timeline that I'm establishing follows the timeline established by the doyen of international legal history, Marty Koskiniemi, who points to the 1860 founding of the Institut de Droit International, and here are its founders. The founding of this professional society in the late 1860s, early 1870s. He points to this moment as the advent of the modern profession of international law. It was at this time that the institutions of the field were established, its societies, its schools, its journals, and its courts. International law became a profession at this period of the late 1860s, early 1870s. There's something mysterious about international law in its first half century, however. It seems that the workers in the field were mostly ignored by those outside the field. Their projects for the codification of international norms went nowhere. Their peace plans were non-starters. The Institut de Droit International won a Nobel Peace Prize in 1904, mostly for its work in arbitration, and arbitration was the area of greatest success for this fledgling profession. But the members of the conclave of international lawyers were not thought leaders during this time period. They were disregarded by foreign ministers. The tribunals they established were lonely places. Their dockets were bare, at least in Europe. But as we will see, their lawyers were busy elsewhere in the world, busy accruing resources for future expansion. And after the First World War, international lawyers undertook that expansion. Their institutions became the world's institutions. They became thought leaders, and they've remained so to a certain extent ever since. They began to profit from the expertise that they had accrued. What about a terminus date for my study? I'll take the start of the Second World War as an institutional rupture which offers an appropriate terminus date. Because remember, I'm defining international law as the field's actors themselves defined it, according to its institutions and professional structures. What came after the Second World War belonged to another era of international law. There were many more states making up the United Nations following decolonization and the proliferation of the state form. The public institutions of international law became ubiquitous. Just before the war, we saw the folding up of the old order, which was embodied by the League of Nations. Egypt, by the way, was the last nation to accede to membership of the League of Nations, and this image of the Montreux Conventions, which negotiated the end of the capitulations in Egypt, came in the same year that they acceded to membership in the League of Nations. They came into the station just as the train was pulling out. The ship of membership, of the use of membership in this international law organization had already sailed. Its supplies were no longer needed, and Egypt had nothing much to gain by trading these supplies. So this is the terminus date that I'm using, the very end of the 1930s, when the old institutions of international law were rolled up, just as Egypt was entering them. Okay, so that's my when story. Where is my second question. International law depends on the scale of the nation state. States are the subjects of international law as conventionally understood. It makes sense then to use states to consider the setting of international law. Let's start with the Institut de droit international, which I referred to already, which was the prestige body for international law. Here. Sorry, I don't know why this isn't loading properly. Let's just see what happens. Excuse me. Okay. With your permission, I'm just going to run these slides from this screen because the presentation mode doesn't seem to be working correctly. Unfortunately, the image will be a little bit smaller than I might wish, but that's just what I will have to do. Okay. So we'll begin with the Institut de droit international, this prestige body. 316 people became members of this body between 1873 and 1939. And this is a visualization of their states of citizenship. You can see that the vast majority were citizens of European states and of the United States. According to this view, Cairo was definitely not the capital of international law. But let's take a look at another body, which was the Société de législation comparée, the Comparative Legislation Society. This group, founded in 1869, was different from the Institut, whereas the Institut had only a few hundred members who could become members by invitation only. Anyone who wanted to take out a membership could become a member of the Comparative Legislation Society. Thus, it was open to interlopers, and we see a national geography that was quite different from that of the Institut. It was initially a Parisian group in the late 1860s, then it expanded to the rest of France. By the end of the 1870s, it was gathering members from around the world. And in this visualization, I'm excluding France because it played an outside role so that we can see the rest of the world a bit more clearly. So we can see that other states are more prominent here. We can see that South America provides many more members. We can see that Romania plays an outsized role, which is surprising and something that I haven't yet been able to figure out. And of course, we see Egypt. Egypt was a consistent presence in the membership of this body. And it was a member in a way that that resembled other states which were consistent presences, like Switzerland, for example. We see Egypt playing a particularly consistent role here, unlike the fluctuations we see in, for example, American membership or Romanian membership in this organization. If we expand the definition of membership to extra-European states and look at the role that they play, we're encouraged to think even further and look at even more specific sites. These sites are subnational sites, cities, and even institutions. And so if we look at cities and institutions affiliated with states, we see that there are actually more cosmopolitan sites than the states themselves. Here's a list of the top member cities, excluding Paris, of members in the Comparative Legislation Society. These are individual members. The residences are listed. So Bucharest, as I've mentioned, Romania plays this outside role, which I haven't been able to figure out. But if we look down the list, we see that this list looks a bit different from what we might expect the list of capitals of international law to look like. Now, my case that Cairo is the capital of international law is not bolstered by this list. We can see that Cairo's in only 12th place, about even with London. A little bit further down, we see Constantinople and New York are partners on this list. But above all, we see that this list shows the role of cities which we might consider peripheral in the geography of international law. And I'll point to Port-au-Prince in particular as a kind of place that we don't often think about as a leader of international law unless we're avid readers of Black Jacobins. So a different geography appears here. And if we push through to look beyond cities at institutions of employment, we see yet another geography. Now, this is not the finest visualization I've ever produced, but let me walk you through it just briefly here. These are the institutions which are listed as the employers or affiliations of individual members of the Comparative Law Society. And once again, I'm excluding France from this table just because the French institution sort of skews the results if we're looking at international questions a little bit. And what we see here is that universities and national courts are the overwhelming source of employment for people who are joining this this international law organization. This means that the day job of members of this Comparative Legislation International Law Society, their day jobs involve domestic law. Truly sort of international legal institutions were a bit more difficult to find. And if we go down this list, we see that the Egyptian mixed courts are the first truly international employment institution that we see on this list of institutions of employment and affiliation. And a bit further down below that, we see the Egyptian law schools, and even cut off at the bottom, we see the service of the Khedive, the Egyptian Khedive himself. So in some ways, these Egyptian institutions were amongst the chief non-national institutions of employment for international lawyers. And it's this institutional location which piques my curiosity about Egypt as a capital of international law. Now, my case, I realize up till now, is not a particularly strong one, but I want to mention a provocative recent book by the legal scholar Anthea Roberts that some of you may have encountered, a book entitled "Is International Law International?" Now, Roberts raises a pertinent question on our quest to understand what is international law. She uses the contents of international law textbooks of different countries to show that a great deal of what we take to be international law is in fact only a domestic variety of the field. So she shows that American international law is very different from British international law, from French international law, from Chinese international law. Their contents differ remarkably. In other words, she shows that international law is a rare and different species from the national international laws that we encounter in the teaching of international law. Now, this finding is even more true in the period that I'm discussing, when there were very few or no jobs calling for people who self-identified as international lawyers. Only at a few venues was, such as extraterritorial legal institutions, was a truly international law formalized and institutionalized. Only there was there a demand for international law experts to do international law. And these venues were located at just a few sites in Shanghai, in Constantinople, and especially in Cairo. So this institutional story is part of the locational grounds for my case that that Egypt was a capital of international law. Okay, so if Egypt was the place where international lawyers could go for jobs, for good jobs, what was the sort of work that they did there? Well, here I'm going to tip my hand slightly to say that the work that they did was overwhelmingly dominated by private international law, by private questions. And so the where of international law outside of the corridors of imperial power helped to shape the what of international law. I'm sure I've not yet convinced you that Cairo was the capital of international law. However, I hope that the landscape I've described here is more global than the traditional picture that you've received. And I hope that you see at least that Egypt was a major entrepot for employment of international lawyers in law that was properly international in content. Let's now turn to look at some of these employees. We can distinguish at least three kinds of Middle East international lawyers. The first is the indigenous lawyers. And here I'm showing a slide of long-standing Turkish and Egyptian members of the Comparative Legislation Society. A few of these people are well known, and you might recognize some names of these long-term members as you look down the list. Now, no historian of global international law has done more than Arnulf Lorca to elaborate a model that describes what lawyers outside of Europe were doing. Lorca calls on world system theory to describe a class of what he calls semi-peripheral lawyers who spoke the language of the core of Europe, i.e. the language of members of the Institut de Droit International, but who acted in the interest of their own national and professional interests on the semi-peripheries of empire. Lorca describes how these lawyers appropriated the discourse of international law and used it to oppose and even to modify the ideas of the core, suggesting that international law became universal through semi-peripheral appropriation. And the indigenous lawyers that you see listed here do appear to fit this model of semi-peripheral lawyers. They were located in Turkey and in Egypt, yet had reason to affiliate with international bodies. And a good example on this list is Nouredungian, the man you see pictured here, who a French-trained Armenian expert. He served the Ottoman government and was a member of the Comparative Legislation Society for about 50 years. He was a very prodigious publisher and produced in the French language some of the major compendia of Ottoman law that the international legal publishing community depended on. But alongside Nouredungian, who was well known and published in the core circles, there were countless other indigenous lawyers who were not members of international associations. Instead, they were workers foundational to the functioning of the edifice of international law. It was their translation of particular circumstances into the language of international law that supplied the essential raw materials that helped to operate this system. I have the names of many of these men, but I lack many more. These men were the members of local bar associations. They were certified to argue at local courts, became part of the international law system through their credentials. But these essential workers do not figure in histories of the field. And part of the work that I'm trying to do in this larger project is to figure out a way to insert their stories into the broad question of the production of international law. And I'll give you some ideas about how I think their content figures in just a moment. But I want to point to two other kinds of Middle East international lawyers before I do that. The second variety of international lawyer was the metropolitan lawyer who made a substantial career in the empire. And I've listed just two names here, which you may recognize from if you've looked in international legal history to some extent. Both of these men, Amin Jean and Mandelstam, came from outside the Middle East to find jobs in the Middle East, where they stayed for many years, building experience and reputation. These men published on Middle Eastern topics and made a reputation for themselves, and then were able to on the basis of that reputation, to leave Egypt or Constantinople. Amin Jean was in Cairo and Mandelstam was in Constantinople, to leave them behind after having been completely imbricated in the institutions and questions of Middle Eastern law. Both men moved from specific publishing on Middle East questions to general matters, moved to European schools, rose in the ranks of the profession, and became pinnacle members of the profession. As they rose through the ranks, their attention to properly Middle Eastern questions waned. So they used Middle East, the Middle East, to develop a specific domain of expertise within the field, but were able to transcend that as their careers move forward. The role of the Middle East was effaced as they advanced. Now, the third variety that I want to point to are people who followed a similar trajectory, but did it much more rapidly. The institutions of law in the Middle East were the most attractive positions for international lawyers during the time period that I'm discussing here. Now, this is just a reproduction of the core data for a data set that I'm currently working with of European employees of Egyptian and Ottoman legal institutions. And I have the names of hundreds of men who came often for very brief periods of employment at very high wages in the Middle East, in legal institutions like the mixed courts. Now, this third variety of people who spend a short time in the Middle East, make money, gather a bit of experience, and leave. This category is not trivia, and it's not meant to be a gotcha. This pattern of employment is recognizable in all sorts of colonial modes of production outside of the law. The extraction of material from the periphery is not surprising, and it's not spectacular. These materials only become recognizable as wealth once they're transported to the metropole and transformed in the metropole, which jealously guards the value that it adds. And so the employment and experience that these many men in the international legal field were able to extract from the Middle East is a consistent source of value for this third group, and of quick value. Okay, I want to turn now to my fourth question. What is international law? made up of if we think of Cairo as a capital and the Middle East as a key supply route for international law. We've glanced at geography, we've glanced at personnel. What of the content? This is the table of contents for the first issue of the major journal of the modern international legal profession. Now, the first piece in this table is the manifesto, which is considered, which occupies a central place in the modern study of international law's history, a manifesto by one of the founders of the field. But the last piece in this table of contents of this opening issue is an essay which has received an essay on the Ottoman capitulations. But this essay has received no attention whatsoever in the history of the field. And the question that I have, what is international law, really exists in the space between this this very well-known essay and this completely neglected essay. Now, there are a lot of excellent reasons why Pradier-Fauderet's essay on the capitulation should be neglected. It's really not a very interesting essay. So that's one good reason. And it definitely looks like padding, and anyone who's ever had to help to put together a journal knows that you have your lead articles, and then you have articles of less and less interest, which have to be there in order to fill out the thing. But it's not always easy to identify which parts of a professional field are the core content and which are filler, nor is it easy to know exactly what the nature of that filler is. Questions of Middle East law clung to the emerging field of international law. Sometimes they were fluff, sometimes mere padding, but often they were important filler for international law, offering it structure and ballast. There is a particular story to be told about the details of the Middle East content in international law, which we can discuss in more detail in the Q&A. But the point that I want to make here is about the bulk that the Middle East topics offered to the publication and content in international law. Now, I'm referring to yet another journal here, the Journal de Droit International, which is called Clunet in the present day, and I've done sort of some full text analysis of this journal, and extracted mentions of different states in the body of articles, and we can see that Middle East states are not necessarily particularly prominent in the academic articles of this journal for much of this time period. We can see that Belgium and Switzerland seem to be more interesting to authors in these of these academic articles. However, if we look at a different section of this journal, the section which contains jurisprudence reports, we see that Egypt plays a more prominent role than we might otherwise expect. So Egypt here in the production of jurisprudence reports, jurisprudence which was essential to the claim of international law to be a substantial field which had something to offer in terms of its expertise in describing the world's legal questions. In the production of these jurisprudence reports, Egypt stands with a variety of other states, and excuse me for a slightly too compact presentation of this graphic, but you can see that Egypt is clustered with far more prominent states, which I'm calling the Club of Nine here. And if we look even further at non-European states, we can see that Egypt produces far and away the most bulletins of jurisprudence, and that these bulletins are quite long and quite substantial as well. So the Middle East, as we can see looking at other states on this list, not just Egypt, but other states as well. The Middle East in general, and Egypt in particular, worked as an informant for this fledgling field of international law. What did the information that it offered look like? It was dry, technical, detailed information. Informants set themselves the task of expounding positive law by reproducing lesser known legislation, treaties, codes, and rules. They organized the drudgery of precedent and systematized their personal professional experience. Their written studies are often repetitive and rarely contain broad-reaching innovative ideas. Above all, their work was less concerned with general public questions than it was with specific private questions. This writing and the work that lay behind it constitutes international law's most tangible influence in its first modern half century. The legal circumstances of the Middle East, specialized but not too esoteric, played a key and instrumental role in the generation of expertise, the development of careers, and the theoretical constitution of international law. Okay, a few concluding words. I would like general congratulations from everyone who's listening, that I, as an Egypt specialist, have made it through most of a talk about Middle East supply routes without showing you an image of the blocked Suez Canal. I'm showing you that image now, but actually don't have that much to say. I won't go on many metaphorical flights of fantasy, in part because my argument is that the Middle East, that there was no major blockage in the Middle East supply route to international law, that this was a consistent, essential, flowing route that didn't experience any ever given catastrophes, really. And I've described two different kinds of flows along this route in the time period that I'm describing, of the second half of the 19th and first half of the 20th century. A supply route of people and personnel, and a supply route of ideas. And I'm suggesting that these people and these ideas offer a useful answer to the question of what is international law. We can trace the vector of these ideas forward, then follow them back to understand their sources and their destination. And we see through looking at some of the ideas that emerge from Middle Eastern international law in this time period, that the destination, the commonly acknowledged, unwieldy body of principles that constitutes international law, was a contingent development. One reason for this contingency is that international lawyers insisted on making up the law themselves. There was not a sense after the 1850s and 1860s that the world needed a set of professional experts to manage the legal dimensions of interstate relations. The authorities who had managed these relationships for many years, relationships of war, treaty, residency, and the like, were statesmen and merchants, not lawyers. They did not want to share their authority, but the international lawyers demanded their place nonetheless. The nature of their imposition is clear in that they were ignored for almost half a century. They formed faculties of law, they held conferences, they formed societies, they issued proclamations from their conclaves, all of the institutions that I referred to earlier. But the makers of war and peace had little time or attention for these international lawyers' ditherings. The international lawyers were singing to themselves. The song they sang, and the song that ultimately won them an audience, was an obscurantist song. It was a song of technical expertise. In order to master the domain of international law, they had not to rescue it from obscurity, but to build it for obscurity in a language and with a set of ideas to which they could claim exclusive access. For this to take place, they needed the exotic. and the Ottoman domains were there to provide it. The question of extraterritoriality was not especially salient within Europe. It was a properly international law question, which didn't apply in European domains. In Europe, convention settled most international questions that arose. There were long-standing traditions that could merely be codified. But extraterritorial questions on the Middle East frontier were more promising for the development of expertise. The centralization of Ottoman, Tunisian, and Egyptian administrations helped, and they furnished job opportunities. But what really helped was the expansion of European investment capital to the south and east. The scale of European investment in Egypt and the Ottoman domains created tremendous volumes of legal work. This work was interesting because it took place in contexts that did not already have theories or experts producing work intelligible to European international law audiences. Codification of commercial and property law in the Ottoman domains ultimately involved cribbing European codes, but someone had to do the adaptation, weak as it was, and that adaptation offered the grounds for expertise. And someone had to argue these cases in court, and this job of argument offered employment for these new international lawyers. Extraterritoriality was the international par excellence because it involved the promulgation of laws by individuals and by corporate persons on virgin territory. It was an opportunity for international lawyers to make their case. The objectification of real persons was part of a change overtaking international law at the turn of the century. It was slowly establishing a distinction between public and private international law. After World War I, public international law, in which states are the sole actors, would come more and more to stand for international law tout court. Private international law, in which persons, both real and juridical, are subjects, developed its own specialists and institutions. The irregularities of the Middle East's capitulations were a perfect fit in this field, which focused on resolving conflict of laws. The great private international law textbooks of the turn of the century, Weiss and von Baer, gave ample space to Middle East questions. It was an excellent source of private international law. Later, after the First World War, the international lawyers had established their sway. The old elites were discredited through this conflict, and the new aspirational elites of international law experts offered its services instead. Part of their work was to begin to take purchase of questions of public diplomacy, which could be distinguished from the private questions that offered work before the First World War. The former Ottoman domains could do yeoman service in this regard as well. As states became more and more firmly set in the role of subjects of international law, it was necessary to have more states, in order to generalize theories of public international law. And so the League of Nations and its bodies and the Permanent Court of International Justice sought out the proliferation of states. Increases in membership bolstered the status of these bodies, and the Middle East offered excellent stock for such an undertaking. Part of the appeal was that the stock was highly malleable. In many cases, these new independent states were still well under the thumb of imperial powers. As such, they were factories of international jurisprudence that could stock the shelves of the libraries of the new international institutions. So to close, my answer to what is international law, private law, and international arbitration and its institutions also answers my questions about who and where were international law. International law, along its Middle East supply route, helps to get at what work was really being done in the domain, and to rebalance our reckoning of where the global field really comes from. Thanks for persisting with me through a lengthy lecture over Zoom, and I look forward to questions and discussion.
Thank you very much, Will, for providing a novel perspective on the origins of modern international law. Again, if you have a question, feel free to raise your Zoom hand, and I can unmute you. You can also either write your question in the chat or mention in the chat that you would like to ask a question. Any of those ways will work. Well, let me begin. Could you talk a little bit about imperial law and its relation to international law? Since many of these places were under the thumb of some other state, it was presumably the home state's legal structure which was imposed upon their imperial possession, and yet the law probably had to be transformed in some way to fit local circumstances. And then the addendum to that is how does imperial law then get picked up or not by this cadre of international?
Yeah, that's an extremely pertinent question, and it gets to the heart of the kind of expertise that international lawyers work to develop. So the field of international law had a very positivist theory that they could come up with sort of a rationalization of the management of legal questions between the individuals and institutions in a more and more interconnected world. But the problem that they faced is that they were dealing with incommensurate bodies of law. So on one hand, we had national legal codes and legal traditions which didn't necessarily align with one another. And this is why comparative legislation was such an interest for these international lawyers, trying to come up with some sort of rational correlation using comparative methods between different national bodies. But to your question, imperial law was sort of an even more complex situation because what you see within imperial law is attempts to translate legal principles from the metropole into the differing rights regimes of peripheries and of subject peoples. So managing the status of differentiated rights regimes was a big part of what imperial law was meant to do. Now, if you're aiming to differentiate, or if you're aiming to reconcile different sets of imperial laws, you wind up having a lot of domains that are difficult to correlate. So you have different laws for different metropoles, and then different laws for different colonies and different subjects peoples. And you need to find some sort of common language between all of them. And the Egyptian mixed courts were one of the key places where international lawyers were making the effort to come up with a common language to reconcile all of these things. Now, in terms of diplomatic efforts to come up with an agreed common language, a consensus around this, this proved to be an utter failure. And this is one of the reasons why sort of the public side of international law doesn't have many successes to point to until after the First World War. But in terms of private questions, especially questions of capital and ownership, it was far more pressing to come up with answers because people's personal financial interests were at play. And so the incentive was strong, and also the incentive to compromise was strong. So provisional answers were worked out often in legal venues like this. And international lawyers who might not manage to reconcile sort of big questions between states would come up with some kinds of provisional answers in more specific cases. And here they would squeeze imperial legal codes to come up with an answer, usually an answer which satisfied the most powerful parties.
Yeah, Tim Waters.
Oh, okay. I don't seem to have a video for some reason. No worries. Thanks. That was really interesting. Just two, I don't know, thoughts or questions. One, when you were talking about the sort of the, rhetorical purposes or claimed purposes of the field, I think you mentioned sort of, a peace agenda and also domination, of course, which I don't disagree with either. I just want to throw a third one out and see what you think about it. But certainly in the period, I know you're not dealing with the post-war period, but if you look at the formal, rhetorical justifications of the field in the post-war era, what's routinely, almost always pointed to first and foremost in textbooks is stability. Right, so not dominance as such, and certainly no longer the peace agenda alone. Those are still there, of course, but stability is usually the prime explanation and justification. So I'm just wondering if you see that in the field in the period you're looking at, and how you would sort of incorporate that. And then the second thing I wanted to ask, you mentioned sort of this what would you say, an agenda of obscurantism towards the end of your talk, and I was just wondering, I was thinking about. In relation to the Egyptian system, I'm no expert on it, but as I understand, and I was thinking about the fact that the journals you're pointing to both have a French address and origin, and might there be another kind of obscurantism here, which is more not exotic travelers dropping in for to get their exoticism and bring it back to the metropole, but a kind of local, shall we say, resistance or agency, which is the obscurantism of Egyptians working out a French legal civil code system under British colonialism. I've often heard this argued as a site of resistance to British colonialism, that this civil law Napoleonic model is being articulated. That I suppose that would explain their enthusiasm for writing things in journals centered in Paris. I'm just wondering what you think about that. Thanks very much.
Okay, well, I am a bit more comfortable answering your second question than your first, as it's a bit more in my bailiwick. But I find your first question actually a very stimulating one. And your question about what role did the ideal of stability play for these international lawyers, I think is productive. I've made a case that that the agenda of these international lawyers it didn't have a lot to show for it in the time period that I'm discussing, and their optimistic stories about what they had to offer as expert managers of international relations were very much bound up with an ideal of stability. Peaceability would be a result of stability, of careful, wise management, and their frustration was that the power holders didn't listen to them, because if only they had listened, things would have worked out fine. But ironically, that message about the public domain didn't really correspond to the positions that the members of these societies were able to occupy in the domain of private legal practice. And here, to return to to the question of empire, they were able to they were able to impose their expertise in institutions which depended ultimately on the backing of imperial violence to impose their will on populations. So stability was not well, stability of a certain kind was what was on offer in an institution like the mixed courts of Egypt, but that was stability for capital, for an investment capital, for finance coming from the centers of power. It wasn't stability for the Egyptians themselves. Imperial subjects were not really being offered stability, and that's not. I suppose that's not at all surprising if we consider the long history of law in imperial contexts. But certainly the stability that was on offer before the First World War, or before the Second World War, was being offered only to imperial centers, whereas after the Second World War and the proliferation of the state form, international law promised stability for all in a way that that it hadn't previously. As far as French law as a site for obscurantism and even resistance in Egypt under British occupation. Yeah, certainly the British felt that French law was a kind of obscurantism and resistance that they were eager to extirpate. And a lot of this fight took place in the lecture halls of rival law schools, British-backed law schools and French-backed law schools in Egypt. But the essential problem here that the British tried to overcome and failed to overcome between the 1870s and the First World War, and even after that, was that the legal regime governing Egypt, the regime of the capitulations, required the assent by treaty of all of the capitulatory powers for any change to be made. And so, whereas the veto power that every European state had over the international legal regime in Egypt, the mixed courts, was really, really useful to Britain and France and Russia and Italy when they didn't actually have effective control over Egypt. When none of those states had effective control over Egypt, veto power was great for them. Once Britain had effective military control over Egypt, they were a lot less interested in other states having veto power, but they just never really found a way to eliminate that veto power. And so they weren't able to rearrange the institutional arrangements in Egypt. They had to share authority in a way that was uncomfortable for them. And this shared authority, this sort of veto power in the hands of the many is an important reason why I think of Egypt as a setting of truly international law and international jurisprudence before the First World War. So we can think of the practice of French law in this time period as a form of resistance, but we can also think of it as a form of internationalism, the coexistence of different schools of law, different approaches to law was a fact of the sort of the shared jurisdiction over Egypt's law institutions in this time period, and that was a frustrating site of resistance for power holders, just as international law is in the present day in sites where no single power has hegemony.
Thank you. There's a couple questions in the chat. I'll just read them to you. So the first one comes from Hanin Amira. As a Jordanian citizen originally from Palestine, I would like to thank you for highlighting how Palestine is still taking a back seat when it comes to international law. There's still a snail's pace pertaining to acknowledging the conflict taking place there. My question is, will there be a possibility in the future of highlighting the conflict taking place there within the domain of international law?
Well, I am going to not going to prognosticate on the question of Palestine simply because in a lot of ways nothing nothing much has changed in many decades in a fundamental sense, except sort of a deeper entrenchment of existing patterns. But what I hope that the approach that I've taken can offer is a kind of a reconfiguration of the sense of who are the producers of international law. And so if we look, if we think about Israel-Palestine as a sort of a leading international law problem in the present day, and we think about who the workers are in this conflict, we can see on the one hand that it is a huge provider of employment for experts. These experts are lawyers, obviously, are members of international organizations, are experts at foreign ministries, are workers in think tanks, are academics. So we can see that it provides a lot of business for these experts. And I'm not saying this completely cynically, but I will say that we can also say that you know, the persistence of the problem is a source of persistent employment for experts in the field. In another way, we can think about, you know, who are the fundamental producers of the legal, of this ongoing legal dilemma, and these are the people, I think, who are subjects to this dilemma. And you know, it certainly includes the millions and millions of Palestinians who are living under legal circumstances which are problematic, which are the source of ongoing work, legal work, and the struggles of their life circumstances are in many ways the raw material which produces this edifice of international law. And part of what I'm interested in doing in my historical study is to point to and validate the labor, the inputs, the lives of all of these people who are caught up in the domain of international law, which is productive of prestige and wealth and ideas and expertise for some, and is consumptive of the life energy of others. So, you know, this is a structure of exploitation similar to other structures of exploitation, and you know, law can function in this way as well, and we see this quite clearly in the case of Palestine.
One of the challenges of being an historian is you do get asked questions about the contemporary world. So here's another. This one comes from Patrick Lee. More recently, have you seen a new frontier that has played a prominent role for international law development, or is the Middle East unique in the role that it played?
Yeah, that's that is a testing question for me, because, you know, like everyone, I wish I understood all the parts of the, I mean, I pay attention to some parts more than other parts, and so I'm reluctant to continue to claim that the Middle East plays a role, an outsized role in the present day. And I suspect that there are there are reconfigurations of power and production of legal questions that we're not going to be able to, that are happening right now, that we're not going to be able to recognize for many decades to come. Certainly, the Middle East continues to play, if we're thinking of questions of international commercial law, the Middle East continues to play a pretty significant, a pretty pivotal role in lines of production and transport and supply. And if you've seen Laleh Khalili's recent book, Sinews of War and Trade, that sort of infrastructural look at global markets, I think can also be aligned with thinking about law in the present day. So you can think of the Middle East as an entrepot for private international law in that regard. But I think that there are lots of other nodes that seem to be equally important. But to retreat to my area of historical specialization, with apology, I'll say that I think that the Middle East did play an outsized, a stronger case can be made that in the time period I'm interested in, and especially before the First World War, the Middle East did play a larger role, simply because it was a domain of what the international lawyer James Lorimer called the domain of the barbarous domain, which is to say the domain which was not quite the domain of savages, which is to say people who had no rights at all and had to be utterly, utterly subjugated. With China and Japan and the Ottoman Empire, Egypt was an area of barbarous law, which is to say these people were not quite like us, but we have to kind of reason with them. And for international lawyers, in my time period, this was really the place where they had work to do. They couldn't insert themselves in the relation between European states because statesmen and businessmen were already handling those relations in a way that worked well enough for them. They didn't have need for the insertion of other experts. But in the Ottoman Empire, in Egypt, in Japan and China, and some other places besides, there were questions to be answered about how to manage relationships, and international lawyers found their place there. Outside of those areas, in the areas of what they call savagery, and we can think of sub-Saharan Africa, we can think of South Asia here, other areas which were considered beyond the pale of legal estimation by these international lawyers and by imperial powers, there wasn't much role for lawyers to play because the people there were considered to have no rights at all. So these intermediate places like the Ottoman Empire and Egypt played a special role in this time period, and I think that the ranks of fortunately the ranks of savages have that area has gone altogether, but I think much of the world is still treated as barbarous and plays a more prominent role now.
Yeah, to me, I think one of the most striking things about your talk was the realization that there's so little intrastate international law in Europe at this time. When we think of Europe as the locus from which international law emerges. So that was fascinating. Faisal?
Thank you, Carl. That was a very interesting talk. And I just sort of have I was trying to decide whether your rather cynical view of international law is one that you still maintain with respect to sort of current contemporaneous international law. It seems to me the last remark you made in answer to the last question answers that question in the affirmative. And so I've got an observation and a question. A very quick observation is you talk about sort of international lawyers creating, you know, their own sort of arcane language. They belong to their own societies. They go to their own schools. Well, so do historians, right? I mean, you've got your own methods. You go to your own schools, wonderful places like Princeton that give you advanced degrees and so on. And you create your own methods and your own language and all of that. So every profession does that. Number one, I don't think it tells me anything about the substance of the field study to tell me that it has an obscure language of its own. Necessarily, doctors certainly do, but so do historians and other professions. So that's the observation. So the question is, if you maintain that sort of skepticism of international law into the modern era, which I grant is not the period of your lecture. What do you replace it with? What do you have? And I take your point. This, you know, whenever I teach courses on international law, I always make this point that it simply didn't apply to whole swaths of the world because they weren't a part of the civilized community of nations as international law conceived of them. But what, I mean, do you have some other method of sort of trying to set state relations and the rights of states, etc.?
Well, yeah, I mean, you have put your finger on the weak point of,
And I'm sorry to interrupt, but I take it that's what Professor Waters was talking about when he was talking about stability, right? Because it gives a certain amount of predictability to relations between states, even if we know that really powerful states, you know, fudge on what international law is. And even if it turns out that it's states like Liechtenstein that are really married to concepts of international law. But what do you replace it with? I'm sorry, I know I interrupted you, but I did mean to refer to Professor Waters' question.
thanks, yeah, no, and I mean, that clarifies that question usefully for me. You've put your finger on, I think, one of the great weaknesses of the historical profession, which is its dogmatic cynicism. And you know, that your point is well taken. However, one of the strengths of the historical profession is that that nobody really listens to us, and this is different from the international legal profession. So you know, we all have our faults and virtues. But I guess if you know, to try to answer your question, I guess my my intervention isn't meant so much to describe some sort of positive alternative agenda, as it is to attempt to diagnose some unseen aspects of a historical reality that presented itself as one thing, but maybe functioned in another way. Or I should say that the role of a bunch of important actors in the production of international law has been neglected, and a big part of what historians often do is try to uncover these neglected or elided or invisible stories. Now, if I can be allowed to refer to the Ever Given, that boat blocking the boat blocking the Suez Canal. One thing that, you know, and refer to that metaphor. One thing that incident did was, showed that when the regular flows are interrupted, in some ways, the reality of the structure is revealed. It's invisible the rest of the time, but when it's blocked, suddenly we realize, oh, this is what's going on. What a fragile situation we live in. And I think that we could maybe say something similar about the stability which international law offers most of the time. When that stability is interrupted, or when that promise is when that promise is suspended, perhaps the reality of what's really going on becomes a bit more clear. Now, we could talk about public law incidents, and of course you yourself, Ambassador, have deep expertise in this area, in the the time of exception that we saw in Iraq in the 21st century. But we can think about Syria in the present day, right, as a blockage of the stable role that we normally think international law might guarantee in conflicts of this sort. And I think that for me at least, it's an object lesson for the limits of understanding that conventional tools offer us for a conflict of this sort. The sort of solutions that international law is supposed to offer seem not to function at all in this context, and it's hard to even imagine what's supposed to function here. And that for me is scary, and it's also very revealing. And if we think of counterparts in the domain of private international law, we can point to climate change and the externalities there. We can point to these present questions about offshoring profits, or we can even think of international investment dispute arbitration as examples where we can see blockages, excesses, questions which are supposed to be managed, which aren't getting managed. And it's here that I think we have motivation to probe for a better understanding of what is international law, because serious weaknesses get revealed at these junctures.
There's another question in the chat from Anna Gaston, similar in some ways to Faisal's question. When a lot of the instability in the Middle East has been fueled by US action and ignored by the international community as a whole, how do Middle Eastern countries, specifically Egypt, maintain a foothold as an epicenter or active player in international law despite their sovereignty being threatened by actions of global superpowers?
Well, so I'm going to take the opportunity of this question to try to return to the terms of my analysis, and say that I'm interested in trying to conceive of the who and the what of international law, and trying to specify that a little bit. And one of the very sort of observing the troubled career of law in Egypt over the last half century, let's say, one of the things which is curious is the presence of Egyptians in the highest reaches of the international legal profession. And there's an amazing book which I recommend to everyone, called Dealing in Virtue. And it's kind of an ethnography of the international commercial arbitration field. And I'll drop this in the chat, this reference. It's really an amazing piece of writing. One thing that's very strange about, and the authors even have a chapter about this, is kind of the Egyptian and Middle Eastern supply route within this field in the present day. Now, how is it that that Middle East lawyers play such an outsized role in the international private law? I mean, I think it has something to do with a long tradition, a long-standing habitus of participation in these kinds of discussions, which occur in a channel which is separate from the role that Egypt plays in international politics and international relations. So that private channel and the more public channel seem to not be entirely dependent on one another. Or I should say there's a delay of decades in the way that one influences the other. Certainly I don't think we're going to see, we don't see the conditions in Egypt right now for the emergence of well-trained, powerful international lawyers. That's not something which can happen under the present circumstances in Egypt. And Egypt, obviously, its government and its authorities have chosen a different course to try to maintain its power and standing internationally, and a course which I think is not doomed to last for a long time, to be sustained for a long time. Okay, this is interesting. Yeah, well, I mean, I find this book is just an amazing book. But individual Egyptians who had of the particular kind of international legal profession which emerged as a result of the Middle East special role, seem to have been able to find very prominent and important spaces in the profession globally over the last half century. Unfortunately, this has not paid off very well for Egypt itself. So the feedback loop is well, I referred to a few lawyers in the first half of the 20th century who were able to establish their bona fides in Egypt and then move beyond Egypt and forget it altogether. And I think that pattern persists in the 21st century. And yeah, even a man as well known as Mohammed Baradei, who attempted to return and maybe become president, wasn't able to translate his international standing into domestic political power. Sorry, that was kind of a rambling answer to your question about Egypt.
Well, we are out of time. Next time we see you, we hope to see you in person here in Bloomington. We will see if we can find a way to bring you once the pandemic is over. It's been a really interesting discussion on behalf of all our guests today. Thank you so much for joining us, and have a great evening, everyone.
Thanks for the questions and discussion. I appreciate the invitation.